This afternoon, I'd like to make a statement to respond to Mr. Niko Nawaikula's social media statement. This is because we have seen that Mr. Nawaikula's social media post has garnered significant attention from the public, and we would like to respond to it. First of all, I'd like to point out that Mr. Nawaikula has got the law wrong when he suggested that the Supervisor of Elections is actually advising the Speaker. The Speaker of Parliament is an independent authority with a set of staff which has qualified legal professionals as well as constitutional mandated legal advice from various offices. As such, it does not have to seek, and it did not seek the advice of the Supervisor of Elections. And this is an incorrect assumption by Mr. Niko Nawaikula. Mr. Nawaikula has also incorrectly contended that even though the Social Democratic Liberal Party has been suspended, the parliamentarians should have been afforded the opportunity to participate in Parliament. This is an incorrect assumption both on fact and law. I'd like to clarify this by raising the following, which are now significant features of the Fijian electoral system. Under the electoral system, nominations at the general election are done by political parties using party lists. All candidates for the election are all candidates for the election by the party are listed by order of preference in the party list by the party. Once all the results are in, the Supervisor of Elections prepares the final national results tally, which contains the total number of votes achieved by each candidate listed in descending order within the party. The total votes received by the party is used to determine if that party has met the threshold of 5%. If the party has met the threshold, then the Electoral Commission determines the number of seats that the party will occupy in Parliament. The Electoral Commission will then fill those seats from the candidates of the party from the final national results tally. It is a party-based system. In the case of the suspended Social Democratic Liberal Party, there are 21 seats, and the 21 candidates who have received the highest number of votes from that party are currently in Parliament or in suspension at the moment. Those parliamentarians are in the Parliament representing their party and cannot claim entitlement to the seat in Parliament personally. It is a party seat. Therefore, as per the Political Parties Act, once the party is suspended, it cannot hold itself out or function as a political party. This would include its functions to be present in Parliament. In the National Federation Party suspension case, the High Court, at paragraph 21 of its ruling, had upheld that the registrar was correct in announcing that the party could not operate, function, represent, or hold itself out to be a political party. The judge said, once a political party is suspended, there is no such political party in existence before the law during the period of suspension, and therefore it cannot operate as a political party. Since the party has not been deregistered yet, Mr. Nawaikula, in referring to Section 20 of the Act, is rather putting the cart before the horse. Since there still remains significant time to remedy the contravention, going any further on the effects of Section 20 is rather moot at this point. At this time, ladies and gentlemen, it is of paramount importance that officials in the suspended party act on remedying the breaches, if they have not done so till now, instead of making such poorly researched statements in social media. Having perused such statements, I am obliged to clarify the legal position, and on the same note, I caution Mr. Nawaikula to seek proper legal advice before he produces such articles to mislead the public. Well, first and foremost, the position in law that he has taken is wrong. And if he's got the law wrong, no person should make such statements. If you do not know the law, you must do some research. Ask someone who may know the law before you make some statements. It is abundantly clear in this case that the reason why they had to vacate from their offices within the Parliament complex was because the party was no longer in existence, as the judge has even upheld in the National Federation Party case. So when he is alluding to the fact that if the party is deregistered, then they can go back into parliament as independents, which is a point of law that is not yet even necessary for us to consider, because they are currently in suspension. So in whichever capacity he is making these statements, it is an incorrect statement on the law. And the fact that the statement has been made without any care to ensure that it has actually been vetted, at least for a second opinion on the law, is just a sign of playing to the gallery, attempting to get attention. I think they should use this energy in remedying the breach, sorting out the office holders of the party, so that the party can be brought out from suspension and can be allowed to function. One of the things that don't apply publicly is your parliamentary privilege. And in this case, if there is continued statements being made about incorrect interpretations of the law, of course very soon he will realize that he doesn't have that many followers who believe his interpretations of the law. And as the Fijian Elections Office, we've always held the view that we will clarify fake news, we will clarify false or misleading statements to ensure that Fijians are not misled. I think it is of national interest when such statements are made where the law has been incorrectly or wrongly interpreted, for the Fijian Elections Office to clarify it. And we are using the means of traditional media to ensure that the right interpretation of the law is made available to the public. And with the traditional media and its responsibilities and the high standards that it upholds, I'm sure that the traditional media will do justice to ensure that the public is not misled.